Hey everybody, Laura here with Legal Talk Tuesdays. And this week we're talking about estate planning, which is planning for kind of the inevitable what will happen, if something goes wrong, not just with you passing away, but also when you're talking about healthcare issues. And we're specifically going to talk about living wills today, sometimes called advanced healthcare directives. And the reason that I picked this topic for today is that I had surgery last week, and that was one of the first questions that I was asked if I had an advanced healthcare directive that I could give to the doctors in case something went wrong during my surgery. And it got me thinking all of the times that I've done living wills for my clients, there are a lot of questions about what it is and what it does and what it doesn't do. And so I just wanted to take a minutes to explain kind of what the living will is. I'm going to age myself a little bit, but a good kind of form of reference or frame of reference is if you know anything about Terry Schiavo, which was a case in Florida where a woman became permanently unconscious and was only alive by machines. And there ended up being a pretty nasty court battle between her husband and her parents on what to do if they were going to keep her alive with these machines, even though there was no chance of recovery and her waking up, really. And when I say no chance, I think it was like a very slim, like 5% chance or something like that. And, it was a long, drawn out court battle. She did not have an advanced healthcare directive that expressed her wishes. And she was unconscious, so she couldn't say anything, obviously. So that's where that living will kind of comes into play. The living will is if you are unable to express your own desires on being kept alive on machines, basically, if you are terminally ill. So let's say that you've been given a cancer diagnosis that has 100% fatality rate. Again, personal story. My stepfather was one of those people. He was diagnosed with a rare form of lymphoma back in 2007. And it was a very quick, once he got diagnosed, got diagnosed in the hospital, never woke up. Really, they had him on treatments and things like that until they basically woke him up in order to sign his own DNR. DNR meaning do not resuscitate and don't keep me alive on these machines, because he was never not going to be off of these machines. He would have had to basically live on machines. And he was told, like, his diagnosis was terminal. There was no possibility of recovery or going into remission or anything like that. And so, that's just kind of a personal example of what that means, that terminal illness. It's some kind of illness that you are going to die. It's going to be not, in years, we're talking, days, weeks, months, that kind of thing. And you don't want to be resuscitated. You don't want to have CPR given to you if you happen to, have a heart problem while you're in the hospital or even at home and are taken to a hospital. You don't want to be kept alive with IVs or tubes down your throat to give you nutrition or hydration, that kind of thing. So terminal illness is one of the options there. And the other is permanently unconscious. And that, can mean a couple of different things. It's going to depend on whatever hospital, whatever doctor you're with. But let's say that you are in some kind of traumatic event and you become, maybe brain dead, but your lungs are still working, your heart is still working. Do you want, a lot of people have very personal feelings on this kind of thing. Do you want to be kept alive? Do you want them to, continue to give you that artificial hydration and things like that, even though there's no possibility of you recovering brain activity? That's what that do not resuscitate, that's what that living will advanced healthcare directive, that's what that's for. A lot of people get confused when I say unconscious. They're thinking about, maybe I get in a car accident and I go to the hospital in an ambulance and I'm unconscious. It does not apply there unless you have, a terminal illness or something like that, and you've asked to not be resuscitated if you happen to be unconscious. So there's some nuances there, and that's why an attorney can be helpful in order to answer these questions and figure things out for you, or help you figure things out. Sorry, my dog is eating a pen. No, buddy. Oh. That's what happens when you go live and you have an animal, or I suppose a kid, but I don't want him to choke and die since we're talking about death and things right now. He got my pen off the table and was eating it all apart. So my lovely MyVirtual.Lawyer pen is now no longer. So back to what I was saying, it doesn't apply in those situations where you get, like I said, in a car accident or something like that. You can also make very specific instructions on qualifiers. And what I mean by that is, let's say that you have an event to where you're unconscious and you want the doctors to do everything they possibly can for a period of time. So maybe for 2 weeks, you want to be kept alive on, every machine, every IV possible. But then after a period of 2 weeks, you give the doctors the instruction through this document, you give the doctors the instruction to go ahead and let you go peacefully. Those kinds of things, you can be very specific with it. And so just a couple minutes on what the Advanced Healthcare Directive, also called the Living Will, what that means, what it does. And, it's just a very important document to have because, again, we all have very personal feelings about whether we want to be kept alive for, ever, no matter what, or if we want to be kept alive for a certain period of time to try to give your body a chance to fight off whatever the issue is, or if you want to have the doctors just go ahead and let you pass away peacefully. That's basically what this document is. The other documents that you need for estate planning purposes, things like the healthcare power of attorney, that's something totally different, and it doesn't override what you have expressed for yourself in this living will. But you also have the power of attorney for your finances and kind of general property, things like that. And then you have your will specifically. And so I'd love to talk to you guys about, what your options are if you want to, get that in place for yourself, your spouse, especially if you have children. It's a really good idea to go ahead and get a will in place because you can, name your preferred guardians for your minor children. I've had clients in the past who've waited until their kids are 18 so that they can give the kids, have the kids be the beneficiary of all their stuff, and that's fine. But, what happens if you die before they're 18? So if you have minor children, it's a good idea to go ahead and get that plan in place. So what we'd like to do is we're going to offer free consultations through the month of May. Normally our consultations are $20, but we're going to offer free consultations through the rest of April and through May in order to be able to answer your questions and see if we can help you out with getting your ducks in a row, basically. And I appreciate your time today. I'll put a link to my consultation calendar in the comments below. And I look forward to talking with you and seeing if we can help you get things figured out. Thanks so much and have a great rest of your week.